Last time we talked about the role of an executor, and another question that often comes up when we're talking about executors, especially in the professional context, is the payment of executors. Now, there's been a lot of cases over the last 10 years which have revolved around professionals and their expectations and their want for payment for acting as an executor. The first starting point there is that when most people act as executors, it's actually a gratuitous position, so there's no expectation of payment. If you're asked to act as an executor and you're a professional, that changes the scenario a little bit, and there is often an expectation and often an understanding from the client's perspective that you do wish to be paid for that service. There's generally three ways that payment can be made to an executor. The first way and the simplest way is actually providing for that under the terms of the will. So the will itself will provide a clause that gives a fixed dollar payment, for example, or an hourly rate for someone working in their professional capacity. If that clause is actually included under the will, it's quite important if you are acting as the executor to make sure that you understand what you can and you cannot charge under that clause, because different clauses will give different parameters. Some will talk about professional charges, some will talk about non-professional charges. And there was actually a case up in New South Wales not too long ago where an accountant was appointed as an executor, and he submitted a claim for the payment for the work that he'd done as an executor. 55.5 hours of that related to organising a funeral. When this claim was actually assessed, the court said, you're an accountant, that's your profession. Organising a funeral, albeit how lavish it would have been, isn't something that you should be paid for, and as a result, we're going to reject that aspect of your claim. So that's one way, under the terms of the will. The second way is, if there's no provision under the will itself, you can actually have a discussion with the beneficiaries and reach agreement with those beneficiaries. So if they're happy to pay you for the services that you've provided as an executor, they all come to that agreement. That's another way that you can do this. The important thing there is making sure, though, that all of those beneficiaries understand what they're actually agreeing to and the services that you've provided. There's been quite a few cases where people have come to an agreement. There's been some cases as well where there's almost been a threat that the estate won't be distributed unless the beneficiaries agree to a payment of commission. And in those instances, the courts have knocked out any agreement. So you need to make sure that if you're going down that path, that all of the beneficiaries have fully informed consent when they agree to that payment of commission. The third option is if you can't reach agreement with the beneficiaries, there's no provision under the will itself, is actually making an application to the Supreme Court. Now, the rules that relate to this area under the Trustee Act and also under the Administration and Probate Act provide that the courts can award an amount of up to 5% for your pains and troubles in acting as an executor. In making that application, you need to talk to the court and explain to the court the actual tasks that you've done. They'll look at the complexity of those tasks, they'll look at how many of those tasks you've delegated, they'll look at whether they're professional or non-professional tasks. They'll also look at things such as the size of the estate, its complexity, how difficult the beneficiaries were. So there's a lot of different factors they'll consider, and they then have the ability to make a payment. It's really an award of commission of up to 5% on the actual value of the estate. Now, there's no cases I'm aware of where anyone has actually successfully obtained 5%. The high watermark at the moment seems to be around 3%. If you've done a lot of work, it's been quite a difficult, complicated estate. In most cases, the awards seem to be around the 2% mark, and there have been other cases recently where the courts have either made no award for provision on the basis that all of the work that the executor has supposedly done has actually been delegated to lawyers or to accountants, or awarded a very low amount on the basis that a lot of the pains and the troubles that have been experienced by the executors have been as a result of their conduct in not actually disclosing certain information to the beneficiaries and not working with the beneficiaries. So if you are appointed as an executor and you do expect payment, it's always a good idea to have a look at the terms of the will, make sure that there's a charging provision in there, and if you're not sure, get advice on the matter. And that's where we can help if needed. That's a short overview on executors and the payment for their services. Speak to you soon.